SJC-12070, Michael J. Ferri and others versus Nancy Powell-Ferri and others.
Nothing like a good decanting case, Mr. Solomon.
Good morning, Your Honors. May it please the Court, my name is Charles Solomont. I represent Michael Ferri, Anthony Medaglia, and Maurice Fitzmaurice as trustees of trusts for the benefit of Paul John Ferri. Your Honors, the certified questions presented to you by the Connecticut Supreme Court arise out of the dissolution of the marriage of Paul John Ferri and Nancy Powell-Ferri. The Connecticut courts are adjudicating many legal issues related to the rights and obligations of Mr. Ferri and Ms. Powell-Ferri. Virtually all of those issues, including the motivations of the trustees, are matters of Connecticut law and proceedings before the Connecticut court, which the Connecticut courts which are well equipped to resolve those issues, and they are resolving those issues. The central question that the Connecticut Supreme Court has certified to this court is very narrow. And that is, did the so-called 1983 trust authorize the trustees to decant to the so-called 2011 trust?
Can I just ask you, with respect to that, just as a matter of general trust law, and the duty is to the beneficiary. So is there conceptually, is there any, putting aside the decanting, is there any ability under Massachusetts law, because I'm just interested, I can't speak to Connecticut, but is there any ability in it conceptually for a third party to challenge a decision of the trustee in this? Let's just assume for the minute that the motive was of doing what was done, although okay on the face of the trust, was a really improper motive, but it wasn't harmful to the trustee. Is there any ability for anybody else to challenge that under Massachusetts trust law?
I'm not aware of any, Your Honor. I mean, the UTC speaks to what remedies are available when there's a so-called breach of trust. And the UTC, it's 203E section 1001A and B, defines a breach of trust as a breach by the trustees of their duties to the beneficiary. So I think that's, as far as I know, that's what I know. Yeah. Again, I think ultimately that's really a matter of Connecticut law.
I know it is. I was just trying to sort of orient myself. I apologize.
So this court has addressed the issue of decanting recently in Morse versus Kraft. And there, the court held that under Massachusetts law, decanting is permissible, where the trust instrument reflects that the settler intended to allow it. And Morse held that where the settler's intent is not expressly stated in the trust, it can be implied from the trust provisions. And in Morse versus Kraft, this court found that three key provisions in the trust that was at issue in Morse evidenced the settler's intent to permit decanting. The 1983 trust in this case has the same provisions nearly verbatim that this court held to establish an implied power to decant.
Actually, they're a little stronger, isn't it?
That's exactly right, Your Honor. I mean, what's more is that here, the 1983 trust has an additional provision that essentially expressly authorizes decanting. And that is, it's section 2A of the 1983 trust. And it says that so long as Paul, the beneficiary, is living, the trustees shall pay to or segregate irrevocably for later payment to Paul so much of the trust assets as they shall deem desirable for Paul's benefit. So Kraft had the same provision, but without the words segregate irrevocably for later payment. And we submit that these words make the intent to decant, if not express, much more clear, because segregate irrevocably for later payment can really only reasonably mean one thing, and that is to transfer the assets to another trust with terms that do not give the beneficiary a currently exercisable withdrawal right.
The Kraft Trust did not provide that when the sons become 35, they can pull out 25%, and when they become 40, they can pull out a larger percentage. So that's the tension here, is that if this provision is kicked in and 100% of the trust is decanted to an irrevocable trust, then the beneficiary loses the entitlement which the settlor specifically provided for to begin to remove the assets of the trust when he became 35.
Your Honor, and that provision, Ms. Powell-Ferri's argument that reflects an intent by the settler to not to allow the beneficiary the right to distribute, to transfer the trust to something that doesn't allow a withdrawal right, that's wrong for at least two reasons. And first, Your Honor, is Section 5A of the trust, Your Honor. And Section 5A of the trust, again, this is a provision that was almost verbatim the same as in the Kraft, and that in Kraft, this court found to be a provision that reflected an intent to decant, says, wherever provision is made hereunder for payment of principal or income to a beneficiary, the same may instead be applied for his or her benefit. So the underlying premise of Ms. Powell-Ferri's position is that, as Your Honor said, 2B essentially gave the beneficiary a vested right to distributions. Well, 5A refutes that expressly, Your Honor. And it says, essentially, even if the right had been exercised, the right to request, the trustees would still be obligated to decant if they deemed it to be in the beneficiary's best interest. Second of all, Your Honor,
Lost you there. I mean, the sentence you read simply says we can pay it to the beneficiary or you can pay it to somebody for his or her benefit.
correct, Your Honor. And again, in Kraft, this court basically said that this provision that authorized the trustee to pay to the beneficiary for his or her benefit was one of the key provisions that reflected the settler's intent to decant. Because again, among other things, the whole concept of decanting is that if the trustee has the right to grant in fee, then it can grant in less than fee. And where the trust says you can do something for the beneficiary's benefit, that reflected an intent to decant. So this basically says yes. I mean, even at the point where the payment has to be made, it can instead be applied for his or her benefit.
I take it, I think your argument would be also that if the trust began when Mr. Ferri was 18, so if at age 34 or 30, whatever, the trustees decided to do what they did later, they could have done that.
Absolutely right, Your Honor.
Completely
Yes.
wiped out any of the distributions.
That's correct, Your Honor. I mean, our position is that, again, they could have done it before, they could have done it after. They had one duty, and that was to protect the trust assets and to act in the beneficiary's best interest. And Your Honor, the construction of 2B would also render 2A essentially meaningless. And as this court well knows, the provisions of the trust need to all be read together. Section 2A says, so long as Paul is living, my trustee shall from time to time pay to or segregate irrevocably for later payment to so much of the net income and principal of this trust as my trustee shall deem desirable for Paul's benefit. So again, one can't give this section meaning without concluding that the trust allows the trustees to decant to a trust without withdrawal rights.
But your brother will probably say, well, your interpretation renders the section about my trustee shall pay to Paul after he has attained the age of 35 years meaningless, because it means that there can be nothing there, that there can be no there when he seeks to apply that.
Well, but the trust, the withdrawal right, the trust is clear that until the withdrawal right is exercised, and the assets are distributed, the trustee retains the duty and the obligation to protect the trust assets and to do what they deem to be in the beneficiary's best interest. And they retain that obligation for so long as Paul is living. And so it doesn't start with until Paul's turned 35. It says anytime he's alive, including after he's 35, the trustees can segregate irrevocably. This doesn't necessarily, they happen to have segregated substantially all the assets, but this doesn't end the trust, Your Honor. In theory, there are still a small amount of assets, and also the trust contemplates that there could be gifts made to the 1983 trust. So this notion, the trust actually contemplates exactly this happening. It basically says, listen, if the trust assets are there, then the trustees have to exercise their duty to do what's in the best interest, and that's protect the trust assets. And what's more, it renders 2A, 2B would, the application that Ms. Powell-Ferri would attribute to 2B renders 2A further sort of meaningless insofar as, again, it doesn't only say segregate for later payment, but it says so much of the trust assets as they shall deem desirable or for his benefit. So, it's not just, the amount that he was able to withdraw until he was 35. It says it's so much even after he's 35. It doesn't limit it in time or the like. So
Let me address my populist concern. If this were an ordinary fellow without a trust fund, and he happened to have $1 million put aside and was getting a divorce, he could not transfer that money to prevent his spouse from receiving an appropriate share at the time of divorce.
if the money were not a trust.
If the money were not a trust.
I would say, I think that, well, the laws of the state would apply, but I mean, the whole entire purpose of a trust is to protect the trust assets.
Right, but this means that rich folks who are smart enough to put money in trust for persons who otherwise didn't earn it can essentially include provisions that say, if you get divorced, we will protect your assets from going to your spouse because we will say these magic words, may segregate irrevocably.
I mean,
That's the consequence of your winning.
well, except to the extent that state law has, state law can apply. I mean, the laws of Connecticut can take into account, however they deem appropriate, and whatever the law is, what consideration should be given to the assets in each or both trusts with respect to the financial orders that they make with respect to the matters, the divorce matter before them. So if that's a concern, I mean, you do have two separate bodies of law, but the body of trust law it's well established. It's essentially almost black letter law in terms of how you construe a trust. And to the extent that there are ramifications of that state law needs to deal with, and that I think in many jurisdictions state law does deal with, that's a matter of state law.
Can I just ask you, I know that a bunch of states, not us, and I don't think Connecticut, but maybe, have statutes about decanting.
Yes, Your Honor.
Do any of them, any of those statutes deal with situations like this where money has been, or there's an effort to decant, connecting, what I'm trying to get at is connecting divorce to decanting? Any statutory terms do that?
Not to my knowledge. Ms. Powell-Ferri in her brief cites a number of statutes. I think there are 23 statutes. And in those statutes, again, I haven't vetted all the statutes, but the proposition is that to the extent that the beneficiary's right to withdraw is changed as a result of the decanting, there are some state statutes that say that don't permit that. Massachusetts has a UTC Act that was just enacted in 2012. It didn't include that provision. In contrast, New Hampshire has a UTC Act that was recently enacted. It did include that provision. So it's really, again, a matter of state law. The legislature has chosen not to put that in the law, and therefore that's not the law of the state of Massachusetts. Thank you, Your Honors.
Thank you.
Good morning. Jeffrey Merman on behalf of the appellee, in this case, Paul John Ferri Jr., who is the beneficiary of the trust at issue. I want to answer Chief Justice Gantt's populist question by just reminding the court of what has actually happened in Connecticut. In the divorce case, the trial court, in issuing her order, dealt with the concern that Your Honor raises by issuing orders in the alternative. if
Yeah,
decanting is,
it's going to take 36 years to get to where the lump sum payments would get to, isn't it?
if decanting is permitted, she gets a lump sum of $12 million.
Yes, but
And
if it's not,
decanting is not permitted,
it's $300,000 a year,
then she
right?
gets $300,000 a year.
And to get to $12 million at $300,000 a year is going to take a whole lot of years.
Yes, it is, but that's what she's asking for in this case, is that decanting is not permitted. So she's asking for her $300,000 a year forever, or until such time as she remarries.
I'm sorry,
Yes.
but no, what I'm,
Wait, she wants the 12 million.
yes,
Well, I don't think she does.
oh.
I guess we're
come.
gonna
Well,
find, I guess we'll
get
find
her
out.
to answer that.
We'll find out. If she wants a 25K, then maybe
The
the question
other
shouldn't be
issue-
here, so.
The other thing that we need to point out is that the trial court also found that she is a creditor of the trust, and that fact cannot be overlooked. I want to spend, just the balance of my time on the issue of the settler's affidavit, and we view Massachusetts law to provide that given that the settler's intention is paramount and is to be given effect to the maximum extent of the law that is permitted, and given that under Massachusetts law, decanting is permitted unless the settler has determined otherwise, this is just the appropriate case where an affidavit of the settler should be considered. Trusts, unlike contracts, are not the subject of a balanced negotiation between the parties. And the law seems to be clear in Massachusetts that the court should consider all evidence of the settler's intent, including affidavit evidence. The Morse versus Kraft Court permitted affidavit evidence from the settler. The trial court in Connecticut, in this case, applying Massachusetts law, should have done the same.
But that would be subject to the parole evidence rule,
No, it would not be subject to the parole
saying
evidence.
that if it can vary the terms of the agreement?
No, I'm not saying that it can vary the terms of the agreement. What I'm saying is that the affidavit of the settler can be used to interpret what the trust instrument means.
If ambiguous.
No, not even if ambiguous. The court in Kraft made no determination that the trust instrument was ambiguous in permitting the affidavit evidence.
But I think the point of these two questions are, if the trust instrument says you shall not pay $4 million to X, and the settler says, I intended to be able to pay $4 million to X, that would completely vary the terms of the instrument. That would not.
Under Massachusetts law, that would be permitted to show that the language of the trust was a mistake. And therefore, this court has held where there is a mistake in the language of the trust instrument, it may be reformed to reflect what the actual intention of the settler was.
Good luck on that one.
This court, in the cases that we've cited in our brief, has said just that.
Those facts, that kind of facts?
On those facts, especially, it comes up typically in the situation where the trust seeks to avoid taxes but has used improper language to do that. And this court has consistently said affidavit evidence is appropriate to permit the reformation of the trust to show the true intent of the settler, even if it varies from the language of the trust. So parole evidence has never been the standard under this court in the interpretation of trust instruments. Thank you.
Okay, thank you. Mr. Walton, good morning.
Thank you, Chief Justice.
So do you want the 12 million or the 25,000 per month?
Your Honor, may it please the court, Ken Walton with Patricia Gary representing Nancy Powell-Ferri. And Your Honor, both Justice Gantz and Justice Botsford have struck right at the core of the issues in this case, so I'm going to try to jump right to those. Yes, if the trust, the original trust is restored, then she would be entitled to the $12 million as opposed to the current format. Unfortunately, my brothers are trying to look at this case in a much too narrow scope than the one that's actually presented, because there are a number of issues that are presented that implicate Massachusetts law. This was a Massachusetts trust drafted here, and Massachusetts law does apply, which is one of the reasons we're standing in front of the court today.
Are we limited to the question that was certified to us?
Yes, they're very much related. And
Are we limited to the statement of facts by the court?
they are part of the statement of facts submitted to the court, yes. We
Well,
did
are
it.
we limited to the facts that were stated by the court?
You are limited to the questions, Your Honor. But I want to just, if I could, respond to one of the questions Judge Botsford asked right at the beginning of the oral argument, which is, how could the trustee be challenged, setting aside the decanting issue just for one moment? How could the trust be challenged on other grounds? And I think the Laura Selly case by this court is right on point, because it says that if, under certain circumstances, trust assets are in fact part of the marital estate. And there can be no honest dispute that what occurred here, the creation of the 2011 trust, was done after my client, Mrs. Powell-Ferri, filed for divorce in an effort to preclude her right to recovery of certain assets. Those are the undisputed facts in this case.
That part of that was litigated in Connecticut.
It was, Your Honor.
And second, insofar as Massachusetts law, you may be going, but that's not one of the questions that the Connecticut Supreme Court has asked us to answer.
It isn't, Your Honor, but I just wanted to respond to your question.
all right,
And
fair
that's,
enough.
I apologize for digressing, but
No,
I heard
thank
your
you.
question.
Thank you, thank
And
you.
I take your question seriously, all of you.
Before you leave the questions, there's a certain peculiarity with them, which is that the first question says, under Massachusetts law, did the terms of the trust empower the trustees to distribute substantially all of its assets? And then the third question says, under Massachusetts law, should you consider the affidavit of the settlor?
Yes, Your Honor.
But it seems as if the answer to 3 is yes, then it would be the Connecticut court which would have to evaluate
You mean the answer to one is
the
yes?
answer to 1. I'm trying to figure out how you have both question 1 and question 3, or whether question 1 simply says, are the terms of the trust clear on its face such that it would be irrelevant whether or not the court considered the settlor's affidavit?
Yes, Your Honor, and I agree that there's a certain overlap between the questions. I can, if I could, I'll just try to take it in parts. On the parole evidence rule, clearly, under the cases that we've cited, the Massachusetts cases that we've cited, starting with the Kerwin case, if a trust is clear on its face, there's no need to look at parole evidence. There's no dispute here that the trust is clear on its face. What we're arguing about is what it means. And Justice Gantz, Chief Justice Gantz, that gets to your point, which is this is not the Kraft-Morse trust. There are significant distinctions between this trust and that trust, as well as the underlying facts in the case. And I'd like to go through those. As an initial matter, as you've already pointed out, Chief Justice Gantz, Section B, Article 2, Section B, calls for a very specific allocation of the principal to Mr. Ferri in accordance with his age. It is undisputed that at the time Mrs. Powell-Ferri filed her divorce petition, those provisions had been triggered. They were within the 35 to 47-year-old age range. And just to show the difference, the argument made by the appellants is that the trustees had unlimited authority to do whatever they wanted to do with this trust. Well, Article 2B says, shall not exceed, the distributions shall not exceed, according to Mr. Ferri's age. That is not unlimited authority. That is significant restriction on the ability of the trustee to make allocations. What the trustees did was ignore those provisions and allowed the entire trust to be poured over into a spendthrift trust, which gives the beneficiaries no power to seek withdrawal.
But couldn't,
I'm sorry.
well, my question was, put the divorce aside for a second.
Yes, Your Honor.
If at age 20 or 18 in one day, the day after the trust is signed, sealed, and delivered by Ferry Senior, the trustees decide in the best interests of the trust, of the beneficiary, they're going to take the entire trust corpus and put it, they're going to segregate it irrevocably for later payment to Paul. Then there would be nothing for him to withdraw.
Your Honor, I agree. But the fact of the matter is, all of these provisions are read in time. There's an A, there's a B, and there's a C. And this trust was set up, and that's why, Your Honor, it specifically says, upon the age of 35, up until 39, the distributions of principal shall not exceed 25%. And then there's a schedule, and it's right in the trust itself, and then
No, that would be at his request.
at his request, but still the trustee is limited because the distribution shall not exceed those specific amounts that are in there.
That's upon his request. That's the way I took it.
But isn't it that 2A and 2B can live in harmony?
That's correct, Your Honor.
In that if there's anything left over, if he hasn't taken a percentage out at these two ages, they can be, the remainder can be segregated irrevocably.
And that's much better said than I said it, Your Honor, but that was my point. And the last provision.
I'm sorry.
I think,
Your point is that, I think
which I'm trying to get to, which
that
can be decanted.
is that if he has not asked for it, they can decant it.
Yeah, that's what I'm trying to, I guess you don't agree with me, but that's okay.
No, what I'm saying, Your Honor, is there is less limitations until he hits the age of 35.
Are you saying that we should interpret 2A, then going to Justice Gaziano's question, that they may segregate irrevocably for later payment to Paul until Paul becomes 35, at which point they are limited only to the percentages that he can't touch? Is that?
Your Honor, what I'm saying is that's one interpretation of that provision, but it's irrelevant because
Or if he didn't exercise that option, and then the trust can be segregated.
That's correct, and it's undisputed, and the appellants do not talk about it, that the sections that we're in, where we are at the time all of this is happening, is right in 2B. 2B is the applicable provision, and it needs to be followed to a T.
But he's never asked for the money.
He has not, Your Honor. He has not. And this was, and Your Honor, if I may, that brings me to the Morse case. The Morse case, the test under Massachusetts law is that, number one, that you need to give the trust its meaning and its intent under the will of Crabtree case. But then, and you need to construe it as a whole, the Morse case, the philosophy behind the decision is, what they were really examining is, we want to make sure to take a step that doesn't restrict the beneficiary's abilities or powers. In this case, so what they did is they allowed the Kraft family to set up 4 sub-trusts for their sons and gave the sons the power because a determination was made that they were now capable of handling their own money. In this case, again, setting aside the divorce and the attempt to shield the assets from Mrs. Powell-Ferri, all the money is now in a spendthrift trust. The beneficiaries have no control over it. In this current trust, they could say to the trustees, give me $2 million, give me $3 million. Trustees could say no. It's the exact opposite of what occurred in the Morse case. And obviously, in the Morse case, the facts were also dissimilar in that everybody was in agreement with how it was proceeding. That's what everybody wanted to have done. And the petition was made appropriately, and the case ended up in this court because the Crafts wanted to make sure that they were not going to run afoul of any tax laws.
But the beneficiary here is quite content with this.
The beneficiary, well, the beneficiary says in the papers that they had no knowledge of this.
But content with this result.
Well, but Your Honor, what we were told in their brief is they had no knowledge of this transfer. So that's actually a question I can't evaluate. I don't know if they're content. You know, I was told that in the papers that this transfer to a new trust was made without the beneficiary's knowledge. And there's others implicated, Your Honor. There's remainder beneficiaries. The Mr. Ferri and Mrs. Powell-Ferri have 3 children who are entitled to future remainder benefits. There was no retirement or college fund set up for any of those children before the filing of the dissolution because of the anticipation of this trust someday funding those things. So with regard to whether the beneficiaries are content, I can tell you that it's my position, although I don't want to extend beyond the questions before this court, but it's my position that Mrs. Powell-Ferri is a beneficiary. Certainly, it's undisputed that her children are remainder beneficiaries.
I'm sorry, how do you get to Ms. Powell-Ferri being a beneficiary?
Well, a beneficiary, Justice Budd, in the sense that under Massachusetts law, because these assets are part of the marital estate, she has a beneficial right, not in the trust sense, but a right to these assets. And again, I don't think there's any dispute that, and it really is at the core, that the reason this trust transfer was done was to avoid that obligation to pay marital benefits.
Just as a matter of interest, under Connecticut law, if, when the divorce suit was begun in 2010, right?
Yes, Your Honor.
Could Mrs. Powell-Ferri have sought to, I know she brought an action and tried things, but it was after. Could she at that point, when her husband was I think at that point entitled to 75%, he could withdraw it, right?
Yes, Your Honor.
Could she have asked the Superior Court judge in Connecticut to basically take some action to make sure that nothing happened to that at that time before the trustees had done anything?
Probably, Your Honor, and to be clear, because I'm not counsel in the Connecticut proceeding, I can't stand here and tell you whether that was done one way or the other. I can tell you this, though, because I thought it was the question you were going to ask me. I can tell you that this, unlike Massachusetts, where the asset needs to come into the marital estate during the marriage to be part of the marital estate, in Connecticut, that is not a requirement. So the only way to actually preclude something from potentially being part of the marital estate is a prenuptial agreement, which was not done in this case.
So, Mr. Solomon understandably is waiving Section 2A and saying, it says, my trustee shall from time to time pay to or segregate irrevocably for later payment to Paul. What do we do with that? What do you say we should do if it does not permit decanting?
Your Honor, what I would say, again, following up on Justice Gaziano's analysis, I think, is that the sections A, B, and C can be viewed really chronologically. Section A takes you up to age 35. Section B brings you to the 35 to 47 time period. And then Section C, which has not been talked about much, but which I find interesting as well, says that upon the death of Mr. Ferri, the remaining income shall be paid for the benefit of one or more of the following: Paul's spouse, issue, and other issues. So there is a contemplation in this trust of a spouse receiving benefits under the trust. And I do think, Your Honor, it would, that frankly, in my opinion, the trust would make no sense if you read it any other way than the way I'm suggesting, because if A could be read the way Mr. Solomon is suggesting, then it would be in direct conflict with B, which puts these limitations on the amount of principal that can be distributed during those time periods. And that provision is nowhere to be found in the Craft Trust, nowhere to be found. You know, what the appellants have picked out little provisions that they think are similar, and they've avoided ones that are completely dissimilar than the provisions in this case. And very briefly, Your Honor, if I may, just on the issue of the actual remedy that this court can issue, under Mass General Law, Chapter 203, Section E, Section 101B, I think there is authority for this court to restore the trust to its entirety and then allow the Connecticut court to take it from there in terms of how the ultimate distribution should be made. If there are no further questions, thank you very much.
Thank you.